She's Mia, actually, not Melody.
Oh, it looks like we may have both. So, all right. So we're live now.
Fantastic.
So welcome everybody to our afternoon session here at House GovOps and Military Affairs. It is Thursday, January 11th, and today we are going to pick up our work on H 649, an act relating to the Vermont Truth and Reconciliation Commission. And I want to welcome back both of our commissioners and Michelle Olvera was the general counsel for the commission, and Damien. So what I've asked is for Damien to start us back up at the top of the bill. I wanted to do a walkthrough with the committee and sort of flag if there were specific questions that folks had that were raised in our initial walkthrough that they want to dive into. I want to make space for the committee to ask those questions and see if we need any more information or if there's specific testimony folks want to hear about a specific section, and just do kind of a working walkthrough where we identify unanswered questions, things we might want to take a little bit more time on, or if there are things that we kind of can say, okay, yes, that makes sense. We're going to move on from that. So with that, Damien, would you kind of remind us where we're starting up at the top of the bill here?
Yeah, so for the record, I'm Damien Leonard from the Office of Legislative Counsel. We're on the bottom of page 1. The bill starts on line 16 of page 1. In the first section, what it's really doing is moving out the sunset or the repeal date for the commission by 10 months from July 1, 2026 to May 1, 2027. So the big question there is probably whether 10 months is the appropriate timeline. And other than that, it's just a date change. So any questions on that? Okay. The next section, section 2, amends the term of the commissioners and specifically the end date of that term. It also moves that out by 10 months from July 1, 2026 to May 1, 2027. So if the date in section 1 changes, the date in section 2 should also change. Moving on to section 3, this reconstitutes the selection panel. So there's a couple questions for you here. First, it constitutes it as a panel of 5 members: the executive director of racial equity or designee, the executive director of the Vermont Center for Independent Living or designee, an individual appointed by the Speaker of the House who cannot be a current member of the General Assembly, an individual appointed by the Committee on Committees who cannot be a current member of the General Assembly, and an individual appointed by the Chief Justice of the Vermont Supreme Court, who can be anyone. So first question here is, are the appointing authorities appropriate? Second question is 5 members appropriate? Third question is, if the answer is yes to both of those, are there any tweaks in there, such as allowing current members of the General Assembly, providing that none of the members could be a current member of the General Assembly, et cetera? So there are variations here. Just things to think about is, how do you want that constituted? Because this will be your panel that fills the empty commissioner slot right now. And we'll also have essentially oversight if there's an instance where, say, a commissioner engages in illegal activity at some point in the future. This would be the panel that would have the authority to meet and either reprimand or remove that commissioner if necessary.
Have any background on why the initial version precluded legislators, members of the General Assembly from being?
So the thinking at the time was an effort to try to insulate the commission from the political process as much as possible. So the goal was to get a commission that didn't have a political agenda and was insulated from the political process and could pursue their work investigating systemic and institutional discrimination within state government without having to potentially worry about political favors, et cetera. So that initial process, it was actually a two-step process where there was initially a panel composed of the similar group of individuals to the individuals you see here, who then selected a selection panel that then selected the commissioners. This is simplifying it because that process was cumbersome, and right now we need to get a commissioner quickly. And if you're going to leave a panel in place, it probably makes sense not to have at this point, because the commission has already experienced delays, to have a process that'll take 6 months just to get to the point of having a panel ready to select a commissioner. So this is just, that's why the original process was that way. And specifically with keeping current members of the General Assembly out of that panel was just trying to insulate it from the politics of the building. There's nothing that says you couldn't have a current member of the General Assembly serving. One thing to keep in mind is that this is at the is if you do say who, you know, if you remove that, there's always the chance that the individual appointed is a member when they're appointed, and then they lose re-election, et cetera. So, but time changes a lot of things, and this is let's see, we're in 2024 now, so this panel will be around for 3 years and change, at least.
And is there a provision in this that would allow change in membership of that panel?
Yep. So if there's a vacancy, it's filled by the appointing authority, and the appointing authority can also remove the member for cause.
Okay. Right.
So, for example, if the individual appointed by the speaker was refusing to carry out their duties, the speaker could remove them and appoint someone else who would do the job. And then with the executive directors there, if that role changes, because it's an ex officio or because you're an office role, it will just change to the new executive director.
Representative Higley has a question.
Thank you, Mr. Chair. I was just thinking about little E1 on page 4, talking about the meetings. They could be held by the call of the chair or request of 4 members. I'm just wondering, I don't see anywhere in here where the commissioners are have anybody to reach out to other than this panel, and I'm just wondering if they shouldn't be included in that ask for a meeting. It doesn't. I mean, I suppose if they contact the chair and the chair is more likely than not to grant that, but I just wonder if that shouldn't also be included in there, that a meeting could be set up if the commissioners request it. Again, I don't see any, other than a date, I think it was October now, for a report to come back to the legislature. Who do the commissioners really feel that they can reach out to with questions and concerns, I guess?
I might open it up to our commissioners here. I think, I'm not sure if anybody wants to volunteer and answer from that who's here. I don't want to put anybody on the spot, but that's an interesting question, Representative Higley.
In terms of the who we feel we can reach out in general about any issues that we have been, of course, we reached out to Damien to get this to help process this legislation, and the initial sponsors of the initial bill. We have also reached out to when we've had sort of questions around the legislation itself. In terms of the panel itself, we want to keep it pretty separate because it could create a power dynamic situation with the appointment of a third commission. We don't want to influence that process whatsoever. However, I would imagine, and I haven't spoken to my colleague, but I would imagine if they asked us about some qualities that we might be looking for or some advice on who could fill the gaps that we have currently and as a commissioner, that would be obviously a welcome ask, if that makes sense. And I'll leave the rest to Melody.
I could also add that it doesn't talk about it in this proposed legislation, but in Act 128, it does talk about committee members that the commissioners also can work with to get additional expertise and sort of specialization of different topics. So there will be committee members also. Yeah. Hopefully that answers your question, Representative Higley.
Representative Higley, you're muted.
Yeah, that brings up another question though. This is the first I've heard of a committee. Who's setting up this committee? And what would that committee be for?
So the enabling legislation allows the commission to essentially set up subcommittees that work with the commission on helping to guide its work with the various populations that have been identified, which could include community members, academics, and other individuals who have expertise that would be helpful for the commissioners. So it's essentially, these committees don't have the authority to write the report or make decisions, but they're there in much the same way that a municipal body might set up a subcommittee on an issue facing the municipality to help it explore those issues and then report back to the body that has authority to make a decision. So I'm just thinking of here in our town, our Parks Commission set up a subcommittee that looked at some issues with the park and then reported back so that the commission could make decisions, and that it would work in much the same way here. At least that's how the legislation intended it, was to allow the commission to bring in outside additional expertise that can assist the commission in its fact-finding process.
Okay, thank you.
Yep.
And am I understanding correctly that the panel itself is really about, as it was envisioned when the House General did the original legislation, the panel is about making the selection of, and here we're adding on the power of filling a vacancy. And we're taking the selection panel that was really originally intended to select the commissioners and giving them some additional ability to meet and a power that hadn't been envisioned in the original legislation in order to solve the problem of what do you do with a vacancy.
So it's kind of funny. The authority for the panel to remove commissioners and to fill vacancies was in the original legislation. It was actually taken out during the amendment process after concerns were raised about whether there was going to be a potentially troublesome power dynamic where the panel was pressuring the commissioners. And at the time, the members of House General decided to limit the panel's time of existence and authority to just appointment for the initial appointment. And then as we've seen, the actual original version, which provided for the ability to at least fill a vacancy, is something that we actually, the need has arisen for that at this point. Yeah, this was just at the time, there were a lot of concerns about insulating the Truth and Reconciliation Commission from state government, and it may be that the legislation did that too well.
That was the sentiment I took away from the sponsor's testimony, but I wonder if, I guess my other question on this section is, there were originally 7 members.
Mhm.
And now we're talking about 5, and there isn't a reference in the bill language itself, but I was wondering if you could just clarify the 2 folks who were in subdivision 1 that, who are the members that were in the original selection panel that are not?
So the selection panel was composed of 7 members selected by the 5 people you see in that list. So this section, I think it's safe to say this caused a lot of confusion when I drafted the bill. Probably wasn't my most clear drafting work.
Okay.
But it was a selection panel composed of 7 members selected by a majority vote of the following 5.
Okay.
Which
in the layers.
Yeah, so it was, so the selection panel, the 7 members could be anyone. But they had to be selected by those 5. And then there were criteria below, encouraging them to select selection panel members who met certain criteria. So encouraging them to look for diversity in the selection panel, et cetera. Does that make sense?
Yeah, now we're just saying it's these 5 people.
It's just these people, exactly. So we've gotten rid of the layers and we're just saying it's these 5 people. And then if one of them departs for whatever reason, their position can be filled by the appointing authority.
Representative Waters, that's.
Thank you. This might just be a whole can of worms we don't want to open, but I'm
That's what we're here for.
I'm wondering why, just going back to the very beginning, why there were only 3 people instead of 5 on the commission, and then that way this could all be avoided.
So
Mia's laughing.
Yeah. I think there were a number of reasons. I think some of it came down to cost.
Okay.
So there were a lot of concerns about the cost of the commission. Because the commissioners are full-time state employees. And so there were costs about that, or concerns about that. So the commission was constituted with the smallest possible number of commissioners and a very small lean staff to keep costs down. Other decisions about size of the commission, I think they wanted to have enough commissioners to have some diversity of viewpoints, but they didn't want it to get so broad that you had the potential for gridlock because there were too many people at the table making decisions. And so that between those 2 factors that I was aware of, and there may have been others, Representative Hango, I don't want to single you out, but you were a member of House General, and yeah, so we have 2 members of House General here. And so Representatives Byrong and Hango were both on House General at the time, and they might be able to speak to other reasons. Because I was only privy to what I was privy to when I was in the room. And I know the committee had lots of discussions about the bill as they were working on it. So.
Don't want to put anybody on the spot, but if you want to follow up on that.
Yeah, I mean, we're dusting off some like 2-year-old cobwebs here.
I didn't know anything about it. I was
No,
curious.
sure.
Yeah.
And if I recall correctly, it was about having a streamlined board, sort of saying a tighter group of people who had subject matter proficiency and expertise, being able to like navigate the conversations a little bit more tightly. And then there's also some cost considerations in there. As the legislative council stated, they're all full-time positions. And what was the, if I recall, the pay scale was what, like 3/4 superior court judge?
I think it's half.
Half, okay, something in that range. But yeah, so, and then there was also office costs, administrative costs, there was a bunch of other variables that put a robust apparatus in place, but one that obviously had monetary commitments.
Representatives.
And I'd like to ask the commissioners, after being incorporated for a period of time, do you think that 3 is the right number for the work that you've seen so far? Or do you think 5 would be a more effective group? Yeah, Melody?
Yeah, sorry, I was gonna defer to my colleague, but I mean, it depends on the day. But I think part of the constraints that we have are, you know, basically, which is further on when we're in this evaluation of this particular legislation, are around open meeting laws. So having obviously more commissioners to be able to deliberate and talk, especially in pertaining to planning and figuring out the process that has never been done before, right, would have been appreciated. But I think we are managing right now with 2, 3 would be better. So that's my sort of non-answer. I don't want to commit to saying 5 would be better. It just, like, again, depends on the day. Melody, any assistance
Yeah,
would be
yeah.
greatly.
I would agree. I think it's like when you get more people, sometimes it can inhibit the process. But also, like, there's a reason the committee members, and I thought that was really well done, added to the Act 128, was because that allows us to have a lot of voices, plus public input. Like, we love public input. And so anything we can do to get more voices involved. So you could have more commissioners, but I think 3 would be fine. And then we'll have lots of people who can add their input. We can have up to 30 committee members. Plus
Okay.
anybody who comes to our public meetings. Sorry, do I keep interrupting? I don't know. I hear like an echo.
No,
Okay.
You're good.
that was very helpful. And I think that was, I assume Representative Byron and Representative Hango, part of the logic of having those advisory committees support was that it wasn't just the 3 voices of the commissioners that were going into what would eventually make up the reporting. Any other questions on section 3? I think the one thing I wanted to get on the table was the idea that given that we pretty recently had that panel constituted and that they, you know, made the selections that they did and understand who they were considering before, I would imagine that those appointing authorities that are outlined here would be able to reconstitute that panel and sort of do the process over and get that 3rd commissioner pretty expeditiously. So this seems to be a straightforward way of resolving the issue. Whereas if we, you know, tried to go back and do the 2 panels and, but I think this seems to make sense to me that it's just a simpler way to kind of get the 3rd commissioner appointed. I don't really know that we have to spend too much more time on section 3, but does anybody on the committee have any questions or concerns about the selection panel? All right. That's anything else in section 3?
A couple of notes. There's a end date for their terms that matches up with the end date for the commission. There is a per diem for individuals who are not employed by the state of Vermont. So there will be some cost associated with this when it goes across the hall. And then their administrative and legal assistance is from the staff of the Truth and Reconciliation Commission. So, and that's to avoid having staff costs that we had with the initial selection panel. And it allows them to just utilize the assistance of the existing PRC framework. So. Good. Okay. So, Section 4 gives the panel the authority to fill any vacancy occurring among the commissioners for the remainder of the term. And it cross-references subsections A and B, which are the standard appointing, or which are the existing appointing provisions. Do you have a comment, Michelle?
No, I think that the costs, the per diem costs are from the Truth and Reconciliation Commission's budget.
Yes.
But then that's probably rolled into the ask for more money, 2025. So that's. Right.
So it's actually, that may make it slightly more than what the ask was, because the ask was based on the fiscal note, which didn't anticipate the additional costs for filling the vacancy now. So there may be some need when we go across the hall to have JFO work that up. I can't remember what it's $50 a day for the per diem, but the expenses, I can't remember what the expense allowance is that we use, but it's.
I think it may be worth us talking with our colleagues across the hall about thinking about this. I mean, it's not a huge
It's
cost, obviously, but
less than 1%, probably on the order of like 1/10 of 1% or less of the actual ask for the budget in per diem.
So when I think about that ask, the $1.1 million ask for fiscal 25, that would mean that the selection panel wouldn't be able to do this work until July 1st. And I don't think that's our intention here. So I believe that what we really want to do is either think about that, the per diem costs of the selection panel meeting again, coming from the existing fiscal year 24 budget, or us asking our colleagues across the hall to, make provisions for a small amount in the Budget Adjustment Act that's being considered right now. That way this, do pass this, it could be done right away. Because I don't think from the testimony I've heard to date that you want to wait until July 1st to have the selection panel do its work.
It's worth noting that the language isn't in the bill isn't the fiscal year, even though the appropriation is, but there's an existing appropriation. So we'd really be talking about adding to the existing appropriation just to make sure they don't run into the red for the fiscal year.
Representative Byron.
Thank you. Just while I'm dusting off my cobwebs here, what was the original appropriation you recall?
I think the commission can actually speak better to the amount of funding that's been appropriated. I know the ask for 1.1 million for FY25 was the original projected fiscal year cost, but I know they have not gotten that amount in any fiscal year yet.
That's correct. I think for this fiscal year, it was something, because it wasn't a complete year, it was something to the tune of 750,000. And then there was another like 50,000 given for adjustments. So, but it wasn't a full year, right? The commissioner started in April.
Right.
And you're correct. We haven't had a full year to have that 1.1 so far.
I'll also note that it is one of our most expensive years because we are buying computers for everybody. We're doing a whole office setup, buying, those things. So it's our most, the least amount of money that we have received and the most expensive year. Because it includes setup. So having any kind of, consideration for those per diems to happen, pretty quickly so that we can
Oh,
go
sure.
through the process would be very much appreciated. So I want to just echo that.
Understood. Thank you.
Okay, section 4 continues the theme from section 3. It gives the panel the authority to fill the vacancy, as I mentioned before. Section 5 is a brand new section. And this gives the panel the authority, after notice and an opportunity for a hearing, to reprimand or remove a commissioner for cause, specifically incompetence, failure to discharge duties, malfeasance, illegal acts, or other actions that the panel determines would substantially and materially harm the credibility of the commission or its ability to carry out its work. And then that reprimand or removal can only occur on a majority vote of the members of the selection panel. So I don't have anything to add there, but I'm sure you want to hear from the commissioners on this section and questions.
Representative Higley has his hand up. Go ahead, Representative.
Thank you. Yeah, I've got a question in this part too, as far as who can bring an action or a concern to the panel. It can any member of the public? Can it be only people that are involved in the committee or on a affinity group? Who can do this?
So anyone could bring a concern to the panel. It's up to the panel to determine whether that would constitute cause as laid out in the statute, and then initiate the process. So this is similar to the governor has authority to remove some of the officers appointed by the governor for cause. Any member of the public could write to the governor and say, Governor Scott, I think this member needs to be removed because of whatever cause it is. And then Governor Scott would determine on his own basis whether that cause has been met and then go through the removal process. So that's the way it is anytime we have an appointing authority that has removal for cause. It's up to the appointing authority. So in this case, it's the panel. And if the panel decides it's not cause for removal, there is no appeal to challenge the panel's decision not to remove. It is the panel's call.
Thank you.
Are there any other questions about section 5 in the committee? Wanted to ask our commissioners, and David's suggestion was a good one. Do you want to weigh in on this removal language?
I think that it makes sense because there needs to be a mechanism, like where the TRC in general is holding, we're looking at society in general and expecting a certain level of responsibility, and we should hold that ourselves too. So I think this works.
Yeah, I would echo what my fellow commissioner has stated. We want to be, we hold power and we should have evaluation for that power and take responsibility, because that's what we are going to be trying to model for the state in general, to take responsibility and accountability for actions. So we should have the same process.
Thank you both.
Okay, and section 6 gives the commissioners the authority to establish affinity groups. And so this, as I mentioned in my walkthrough the other day, is a may power. They're not required to establish these groups. We're just specifically giving the authority to establish them if they so choose. All right. Section 7 moves out all the report deadlines by 10 months. So I don't know if the first deadline here moving from next week till October 15th is necessary. I imagine the commission is already working on that report because this law will probably not pass in time to save them from that deadline. But the other deadlines also move out by 10 months. If you do advance this bill and it's after January 15th, and they've submitted their report and don't need the extra time, I would suggest just removing that date change.
Yeah, would it make sense, the committee, to say that we at least make that amendment request to Damien? Doesn't seem to make sense right now to push that particular reporting date.
Right, we have it scheduled actually to go out tomorrow because Monday's a holiday. So I think that's gonna be done.
Thanks. So we'll officially make that request for you, Damien, to strike that date change on line 5 there.
Okay. Oh, I did want to, before I go on, it just occurred to me that Representative Higley had brought up a potential change on the selection panel regarding a timeline to appoint a new member when a vacancy occurs. So back on section 4 on the bottom of page 5, it says the panel shall fill any vacancy for the remainder of the term. And you could add language there. Shall fill any vacancy occurring among the commissioners within blank days after the vacancy, after the position becomes vacant for the remainder of the term. So it's really a question 30, 60, 45. I mean, it could be any length. You just want to give them a reasonable period of time. The only catch is that the initial time it would be, within X number of days after they get that authority. So.
Inclined to make it a little bit on the longer end of that myself, but do folks on the committee have thoughts about what the period of time should be? What were you thinking? I was thinking that 60 days would give them the opportunity to actually accept applications from folks, take some, have multiple meetings where they could interview candidates and try to select someone. Representative Nugent and then Representative Hagan.
I also would love to hear from the commissioners what their thoughts on the timeline was.
We absolutely will. Representative Hango.
I just wanted to comment that, from all the interviewing that I've done for various boards, it's not people's first and foremost job. So to get them to schedule their time according to your time is really hard. So I think 60 days is adequate. Probably not much shorter than that. It would be hard to turn it around.
Commissioners, do you have any thoughts on what language we might put in here around the timeline for the selection panel to fill a vacancy?
I agree with the 60 days. I think I don't know, the process for us was about 30 days, but I know that there was a considerable amount of meeting before they were able to take interviews, including doing a job posting and waiting for that to kind of where the candidates come through and going through the HR process in general. So 60 days should be sufficient. And I feel like if we if you use that language and they get done earlier, then what's the harm?
Yep.
Representative Higley has a hand up.
Yeah, thank you. Another thing that could happen, couldn't it? That the panel, when they're going through this initial process, could keep folks' initial application for the job kind of in the background. And if it happens again, they could reach out and have in advance maybe a number of other applicants that might be worthy of the job. Just a thought.
I think that particular piece of logic, it is undergirding some of our thinking around the selection panel right now. At least from talking to Representative Burrows and Representative Stevens, I think that there's likely not going to have to completely recreate the process because there are likely some folks who might have been candidates who were qualified that we could go back to from the original selection process, given the short period of time that's elapsed here. So, Damien, do you feel like you have what you need to do a piece of language with 60 days? Are there any other policy?
Yeah, the only other question is, so because the vacancy occurred earlier this fall and this bill, even if everything goes really smoothly, it'll be more than 60 days after the vacancy occurred when the bill takes effect. I'm going to need to add a session law section that says, notwithstanding that requirement, the panel shall appoint someone to fill the existing vacancy within. And the question is, do you want it to be within 60 days after the panel is appointed? The members of the panel are appointed? Okay.
I think that's only that's really the only reasonable way to do that, right? Because otherwise we'd be starting the clock on bill passage, and then those folks may not know that they've been reconstituted and have the chair have the opportunity to schedule a meeting. Yeah.
Yeah, an appointment takes some time too. So that's,
yep.
If there's anything I've ever learned, it's never start a study committee on July 15th because we won't have all the members appointed. So it's, that's just something else to keep in mind.
Representative Chase.
If we're starting the clock after the committee's convened, then do we need, maybe shorten it to 30 days?
Well, so
or
we
keep it at 60.
I'm a little bit concerned about putting too tight a time frame on the selection panel, but because they could do it earlier if they can.
Sure.
We're just saying,
Okay.
we're providing a maximum. I don't know. I totally see the logic in what you're saying. Is that I assume that folks will know that this is coming. Many of the members of the original selection panel, I imagine, are going to be reappointed by the appointing authorities. So the time frame could be shorter, but for my money, I think that we can trust them to be as expeditious as is reasonable. But I don't know if you think it should be shorter. I don't know.
I'm good with that. I also wanted to circle back. The term affinity group doesn't appear to be defined by like Webster's or elsewhere in statute. Is that a term of art, or is that something that we need to specify what that means?
That was a term that came from the commission, so I would defer to them on that.
Essentially, group support is what's intended. Mia, do you have a further definition of that?
I'm on mute, sorry. An affinity group essentially is a group that's formed around a shared interest or common goal or commonality of some sort, to provide sort of a place where people feel safety, feel the commonality brings about the safe environment. I hope that was.
Yeah, I understand the intent. I was just asking if we needed to define it in the statute. So, you know, other people
Yeah.
know it kind of thing.
Yeah.
You could so there are a couple of ways you could tackle this without writing in a definition. So one concern I have with defining it is we limit their ability to be creative in how they constitute these groups. So they already say it's for purposes of sharing experiences and providing mutual support at the end. You could just say establish affinity or other groups, and then it's described as in which individuals who have experienced or are a member of a community that's experienced some form of institutional, structural, or systemic discrimination can share experiences or provide mutual support. And I think at that point, when you say affinity or other groups, or something along that line with the rest of the context there, it explains what you're looking at. I think affinity group is, it doesn't have a specific legal meaning, but I think at this point, the context of the sentence provides a lot of that. You could say support or affinity groups, or other types of affinity groups. But I think that becomes redundant when you say for purposes of providing mutual support, so establish a support group for the purpose of providing mutual support.
Or just group.
Yeah, I mean, you could just say establish, you could just say establish groups. It doesn't change the authority there. So it's, at this point, I think it's the language after establish groups that really establishes what the authority is, because it describes what the group's purpose is.
Okay.
Okay,
That's the same thing, define it.
so I guess my question for the commissioners, and for Michelle would be that if we just said establish groups instead of establish affinity groups, does it harm anything?
I don't believe it does. Because what those groups are defined right after it.
Okay.
All right, this is some serious words, I think. It's all right. I don't have a strong feeling about changing it, but do you want to make it broader so that it
Yeah.
has this word that has a
I'm just thinking that it makes it clear for people to read. People who aren't immersed in the topic.
All right, so there's a couple ways that we can approach this. For people who are, I like the idea that we're giving a specific authority. So how would you feel about it saying something like establish groups, including affinity groups, or establishing affinity or other groups, as Damien suggested? Does anybody have?
I was just going to say establish groups for the purpose of blah, blah, blah.
And just take the word affinity out of the
Yeah.
statute. If the commissioners don't have any opposition to that, I don't see a reason why we wouldn't do that. Just give you a broader authority, and you can establish the groups that you feel like will help you do your work. Okay, so we'll just strike that word that might create more confusion than it's worth here, and give you a little bit of a broader authority to establish groups. We'll get that in the next draft.
Great. So getting back to the reports on the bottom of page 7, the final report is bumped out to April 15th, 2027. The draft of that report is due by October 15th, 2026. Again, these are all tied to that 10-month bump out. If for some reason that bump out needs to change, all these dates would just move with it. There is one technical change on line 12 of page 8, where it's the requirements of section 909, not section 910 of the chapter. That's the access to information and confidentiality section. That was just something I caught reading through it, and I forgot to mention in the initial walkthrough. And as I mentioned in the walkthrough in section 8 at the bottom of page 8, I believe, we've added the notwithstanding any provisions of the open meeting law or section 911 to the contrary. And this is the language that permits an individual to have a private interview instead of an interview at a public meeting. Which brings us to section 911. This is the section that allows commissioners to attend and have a quorum if they're attending by electronic means, without being physically present at a designated meeting location. It's basically the pandemic era public meetings where you can have a virtual meeting. So you don't need a physical meeting location where the public may attend, and you don't have a requirement that members and staff be physically present in order to hold the meeting. And then it does require them to, again, use technology that permits attendance by the public, allow the public to access by telephone, video record and live stream the meeting, and then post information that enables the public to actually access or view the meeting. So that, again, is based on our pandemic era requirements. And then the closed meeting provision in there, which allows them to close access to the meeting if there are material threats to the health or safety of the commission, its staff, witnesses, or invitees. And so this would allow them to close attendance at the meeting or participation in the meeting, but still require that the public can access a live stream of the meeting or view a video recording of the meeting.
Yeah, I want to pause here for a minute. So I had a lot of conversations in the last couple of days about what the definition of a closed meeting is. And especially since the word closed was used in a headline recently in regard to our consideration of this bill, I just want to really be clear. So this is saying lines 8, 9, and 10 that if for those specific reasons, threats to the committee, public safety, the commission decides to have a closed meeting, that meeting would still be live streamed and it would still be video recorded. So any member of the public would still have the opportunity to see the proceedings of a closed meeting. It would be live streamed and recorded. Am I understanding that right?
You are understanding that correctly. So it is defined as a meeting that is live streamed and video recording, but is otherwise closed for purposes of physical or digital access and participation. So you can view it, but if you are not invited to participate, you cannot participate in the meeting when it's closed.
And I think we went over this the other day, but I just really, really want to underscore this. So if we closed this meeting today, our Zoom, the digital part of this hybrid meeting, is already closed. Only the commissioners who were invited, Representative Higley, who has the secure link, can get into the Zoom meeting itself. The additional thing would be, you know, if we locked the door right now and had the authority to do that, which I don't believe we do. But if we had that authority and did that, that would be the same as what we're talking about the commission having the authority to do here. So they could have a finding on the record in an open meeting that there was a threat to public safety, that they were going to close a meeting. And then that meeting would be much like if we were in this room having a meeting, it's on Zoom and live streamed, but only the folks who had been invited would be on the Zoom, and only the folks who had been invited could be in the physical space.
That's correct. And this is to address threats of violence to members and staff and invitees there. So it's to address a potential public safety concern. So yeah, it requires that the commission actually find that there is a material threat to the health or safety of the commission, its staff, witnesses, or invitees. And only then can the commission determine to hold a closed meeting. Otherwise, the meetings have to be open to the public.
Right. And I will say under such threat. So for example, you know, that has happened before the meeting or perhaps even during the meeting, right? Because there's always that streaming chat. You know, we just want to be able to have a civil and safe discourse. And when those kind of things are happening, it really just abruptly stops the conversation that people can have. You know, now, having received the threat, the commission might decide we're going to try to have it open anyway. And then if things are happening in the chat, then move to a closed meeting. You know, we're going to do what we can to allow for public discourse, because it's actually essential to the commission and provides the direction of what we're doing. But you know, there's only so much you can do when people are threatening. You're going to do what you can to have that discussion remain safe. So that's what we're asking for.
Folks on the committee have questions about this closed meeting authority? Representative Chase.
Sounds like that aligns with other open meetings and, you know, town meetings and select board meetings and stuff as well. Is that accurate?
I'm not sure I'm the best person to answer that. That's really a better question for Tucker Anderson from our office. I don't know what all the requirements are for a municipal meeting and so forth, so I don't want to misspeak. Okay.
I think he said something different.
Yeah, if I recall Tucker's testimony, we can get him back in here on this too. This is somewhat unique.
Oh, okay.
The very specific language about the finding of a material threat, I think that language does exist elsewhere, but let's get Tucker in to clarify that question. Let's put a pin in this right now. It's a little bit unique. It's not completely unique from other things. And like we here at the State House, for instance, you know, have things in our rules that allow us to remove members of the public. So there's a constitutional mandate that we have to keep the State House public, but that also requires that people are behaving, I can't remember exactly the language, but they have to be behaving in a civil and safe way, or else they forfeit that right. So the Capitol Police can remove people if they're behaving in a way that's threatening, but it's a pretty high bar. And I think here, the finding that there's a material threat is a pretty high bar too. And I think it's a bar that could be challenged, right? I mean, if somebody wanted to say it was inappropriate for the commission to do that, show me why you closed this meeting under this authority. I imagine the commission would have to.
Yes, I mean, I think if, for example, it's part of an ongoing criminal case or something like that, potentially we could just say this is part of an ongoing criminal case and give generalities. So yeah, I don't know if I always want to turn over exactly the threat that we've received, but yes, we would certainly answer why that's happened. And hopefully try to figure out a way that we can deal with that and still continue with the business of the commission.
I did invite the Vermont Press Association, who had expressed some concern about these changes from open meeting law, to testify. They weren't able to come today, but I'm trying to find time when we take this back up next week for them to come in and talk about some of their concerns with us. They seem to be particularly concerned about deviations from open meeting law, but I'm not sure if those concerns were specific to just this language around closed meetings. I know that they've expressed concerns to our committee and the Senate Gov Ops about the particular language in our COVID era extension of the remote meeting authority as well. And I just, I wanted to say while we're here, I want to work with them and other public transparency advocates to make sure that when we are deviating from the open meeting law, which is important for transparency, that we're doing it with really good reason and we're creating a high bar. I personally think we met that here, and that the Truth and Reconciliation Committee, the commission, is doing work that is particularly sensitive to threat. So it's important to balance the need for transparency with the need for public safety in a responsible way for all of us. But I just wanted to say we are going to continue that conversation. I have invited the Vermont Press Association to come and talk to us about their concerns and trying to work out when they can make it. Okay.
Thank you. We appreciate that. And we're on the same boat as you. It is an important one. And I'm glad that people are bringing it up.
That's what we do here. We're having these hard balancing of interests that are legitimate.
Okay, so subdivision 3 there also requires the commission to include in the agenda for any closed meeting information that would allow the public to directly access the live stream of the meeting. And then to post the video recording and make it available for inspection or copying under the Public Records Act. And then the only exception to that is if they go into executive session, they're not required to record that or share the recording publicly.
Can I just stop there? I wanted to ask the folks from the commission if they could just talk a little bit about the circumstances under which you likely go into executive session. Like what are the kinds of reasons why the Truth and Reconciliation Commission?
There's a big list, but mostly it's information that would be confidential, like hiring or privileged information or it's usually something that is confidential or privileged anyway, right? That you couldn't share in the meeting or outside of the meeting with others outside of those groups, about people that are within that duty of confidentiality or the privileged information piece.
Yeah, so I think we have pretty strict limits on the reasons why a public body can go into executive session, and we're not really waiving any of those here.
No, so it's, your executive session reasons are set out in 1 VSA 313. And they include making a specific finding that premature general public knowledge would clearly place the public body or a person involved at substantial disadvantage. And it lists things like contracts, labor relations agreements, arbitration or mediation, grievances, other than tax grievances, pending or probable litigation, to which the party is or may become a party, confidential attorney-client privilege, attorney-client communications made for the purpose of providing professional legal services to the body. So when I was in private practice with a municipality, I would advise potentially we would go into executive session to discuss a legal issue. And then they would come back after hearing counsel to then discuss the issue publicly and make their decision. The negotiating or securing of real estate purchases or lease options, the appointment or employment or evaluation of any public officer or employee, provided that the final decision to hire or appoint is made in an open meeting and the reasons for the final decision are stated during the open meeting. So in other words, if they made a hiring or termination decision with respect to commission staff, they could do that in executive session, but then they have to announce the decision and the reasons. They have to make the final decision and announce the reasons publicly in the public meeting. Same thing, disciplinary or dismissal action. But it doesn't impair the rights of an employee to a public hearing if formal charges are brought. I don't think that's going to apply too much here. Clear or imminent peril for public safety. Records exempt from the Public Records Act. So this would include personal records and information that is covered by the Public Records Act, as well as personnel information. Academic records, not applicable here. Parole proceedings aren't applicable. Pharmaceutical rebates are not applicable. And then security or emergency response measures, the disclosure of which could jeopardize public safety. So if they were to discuss response to an emergency and future measures, they could do that in executive session as well.
These are all general law, though.
This is general, applies to
Right.
everyone. So,
I would add,
yeah,
specific to Act 128, the people that come to us and tell us their stories of discrimination are entitled to confidentiality. So if we're in a meeting and I feel like there's too many details being given and someone's identity could be discovered, I might really quickly stop us, say that in executive session, and then just back away from any identifying information. And I feel like is either given out in a handout we didn't know about, or someone else that is attending the meeting is doing that, like just figuring out a way to keep those things confidential if they're entitled to it.
Representation.
And the individual's right to a private interview is separate from this, right?
Yeah.
Right, but that could be something that would need to be protected. Let's say somebody, because we do talk about cases in general in the meeting, and if somebody attends the meeting and is giving too many details, which I do worry about, then we have to stop it and make sure that doesn't happen.
Representative.
Thank you. So would that be somebody giving too many details about someone else?
Yes,
Who has allegedly been wrong?
right, maybe it was in their community and they might know, right?
Okay, so at that point, rather than go into executive session, if I were running the meeting, wouldn't you just say, we are unable to talk about those particular details at this meeting, but if you would like a private interview, we could set that up for you?
I mean, that's a possibility. It just, there's just a myriad of ways it could happen. Like hopefully a document hasn't been shared or,
But even if
we would do it the
has-
best we could do it. I mean, if I could really see it coming, I might just send a text to my fellow commissioners and like all together we can, make that announcement.
Yeah, so I guess my point is if it already had been shared, it's kind of late at that point to then go say, okay, we're going into executive session.
It would be.
I
I mean, if I just hear a run up to it, like you can hear that maybe the name of the school starts to get mentioned, and then hopefully I'll be on it. I'll be really fast.
Yeah, it's really hard to gauge those things, and I know that the public has already expressed concern about executive session being overused. So I just want to be careful with what we're allowing here.
Yeah, okay, that's interesting and helpful. We have not so far been in executive session, so we've not had to use that.
I think this is just coming out from these hearings that the public is concerned.
Yeah, and it's a good reminder. And if we did, I would definitely say the reason is we're trying to protect the identifying information of an individual that's been generous enough to share and really doesn't need advertising. Yeah.
Yeah, I appreciate you bringing that up, Representative Hango, because I think there are members of the public who've come to us as the GovOps committee about municipalities or other bodies of the state that may have used executive session in a way that is questionable, if not inappropriate. But I just wanted to be clear, and I think the general counsel just made that pretty clear that the Truth and Reconciliation Commission has not used executive session yet. So we're not specifically talking about their concerns, but that our taking up this bill and the fact that closed meetings, I think were conflated with executive session. And that's part of why there was this stir. So when I got feedback after the article that came out after our last session, a lot of the folks who came to me, and I think other legislators on the committee experienced this, took closed meeting to mean executive session. And I think we just did a really good job now of talking about closed meetings still being live streamed, still, the records of them still being available, but we're protecting who gets access to the immediate meeting because of a threat. That's one thing. And then these other things, executive session, are a tool that can be used for a very narrowly defined set of purposes, just like any other body that's subject to open meeting law. I think we cleared that up really well here this afternoon, and I appreciate us kind of beating the dead horse of that. But I knew that there was so much confusion after that article because people were conflating the two things. Representative Hango.
And also I wanted to add that what I have heard is that they don't want this to be an exception to the same rules for executive session that every other legislatively or statutorily directed body has to follow. So that's what I have heard.
And
Right.
the language in here right now would make them follow the exact same law for executive session that everyone else follows. So it specifically provides that it's an executive session, executive session pursuant to 1 VSA 313. So that is the statute that governs when you can go into executive session, what you have to do when you come out, how you go in. And so they're held to that same law. They're not getting a special broader executive session piece here. The reason we added it to the draft was because of this potential. So we're saying for closed meetings, you have to provide a live stream, you have to provide a video recording. We just wanted to clarify if for some reason there happens to be an executive session during a meeting that's been closed to in-person public attendance and participation, that they don't have to record the executive session. They still have to record and live stream the rest of the meeting. So,
Does everybody have clarity on that? So one of my main goals for the afternoon is just closed meetings are one thing, executive session's another, but the executive session might happen in the middle of a closed meeting. And that's the only reason it's in here. I think that's what I just heard from you, Dave.
yeah, and I think it's important to note that a lot of what we're dealing with here is trying to address the what ifs. While providing transparency, as the chair said earlier. So which I guess is a segue to the next piece, because the other thing the article raised concerns about, that the chair referenced earlier, was subsection D of that section 9, which would provide that deliberations of a quorum or more of the members of the commission are not subject to the open meeting law. So as Tucker mentioned the other day, deliberations has a specific meaning in law. And what we're dealing with here is that we have a 3-member commission. So anytime the 2 members run into each other, they have a quorum. So if they wanted to discuss anything related to the work of the commission, outside of the barest operational discussions, such as when are we scheduling the next meeting, they actually are subject to the open meeting law under existing law. So this would allow them to meet outside of meetings to discuss commission business without having to notice a meeting anytime they're having a conversation. And this, I'm putting a flag in my draft here that you're likely to hear from additional witnesses on this, so just to hold it open for future comment. But I wanted to flag that this is the other area that was highlighted in the article and the comments from the Press Association. So,
Representative Waters.
Thank you. I know that we touched on this the other day, but can you say again, there are other 3-member commissions, correct, that also have these exceptions? So this isn't.
I think what Tucker said the other day, if I recall correctly, is we have other 3-member commissions that have this issue.
Yeah.
I think that he said that this language is not currently elsewhere in statute.
Something's like it for the crime.
Yes, there are some similar things, but this.
Oh, right. Okay. Thank you.
For similar reasons.
Yeah.
Over here, I was just wondering if I could add something to that, and sorry to interrupt.
Oh, go ahead.
I don't know if there's been any evaluation on the other commissioners being full-time employees as well. Right? We have a 40-hour work week, right, basically to fill, and not being able to collaborate with an essential colleague without having a public meeting, provide some restraints. Now we are working around that by creating documents and each writing on documents, and we're doing mostly operational right now. But I could see there being, I don't know if any evaluation has been done on how many other commissions have three commissions and they are full-time employees. That's the kind of additional piece that I wanted to just reflect in the space.
Yeah, what Tucker had mentioned is that we've got similar language for quasi-judicial bodies. So quasi-judicial body is parole board or other administrative board that similar to a court will weigh facts and then issue a decision. And so that this is based off of that, but it's a somewhat unique situation.
Representative Boyd and Representative.
The language states deliberations of a quorum or more. So say once the third commissioner is hired, if all three of them could come together and deliberate.
Yep.
Representative.
So I was asked yesterday about the similarity to a three-person select board. And the definition that Damien just gave of it being, of this being more like a quasi judicial board. Where does the three-person select board fit? in
So
that?
I think what I was saying with respect to the quasi judicial bodies is that the language giving them an exception to the open meeting law to allow them to have deliberative discussions without requiring a noticed public meeting is similar to provisions that we've enacted for quasi judicial bodies to allow the members of that body to deliberate out of public eye before they render a decision on a case before them. So obviously the Truth and Reconciliation Commission doesn't have a caseload like the quasi judicial body, but they are hearing and deliberating about similarly sensitive issues. So that's the similarity here. I think Tucker commented the other day that this is similar to a three-person select board in that you have the quorum issue where anytime two members meet, you have a quorum. So trying to pull apart these different snippets from the conversations that we've had. And
It might be worth having Tucker come back in because this is more his area of expertise. So I'll get to doing that if you don't mind parking this particular question and we'll get Tucker back in to talk with us about it.
Yeah, that would be great because there are folks from three-person select boards who would like to weigh in on this because of the feeling that if we allow something for one commission or board, then eventually it's going to pertain to them as well.
Yeah, I think they are separate and distinct policy decisions for us to make. So I think that there is a little bit of, I can totally understand the logic of what's good for this three-person commission that's subject to the open meeting law could be considered good for a three-person select board. I'd say one of the really key differences here, though, is what power each of those bodies has and the kind of work we're asking them to do is a little bit different. And I think one of the things Tucker will talk to us about is if two members of a select board happen to run into each other in the hardware store, they don't all of a sudden have to run away from each other. They just can't discuss business. Right. So that's really the prohibition that they have. And it's not that they're like not allowed to ever see each other.
Yeah.
And so it's I think sometimes when we talk about the municipal boards, we get a little bit wrapped up in the perception that there might be a violation of the open meeting law as opposed to the reality of it. But I will make the time for us to talk about this with Tucker in the room.
Yeah, because they're all kind of paid by taxpayer money, so they all have to be accountable in a similar way.
Select boards get paid.
Some of them, I mean, like a stipend.
Yeah.
Paid.
I was just making a joke as a former city council member who never got a stipend or anything for that. Very nice plaque at the end of my years of service. A little self-deprecation there, Representative. Representative Walker Evans, please say it.
Thank you. Well, I don't know, maybe I'll make it worse. I was to say that I think the nature of the work that a select board does is different from the nature of the work that this commission is doing, and that it's much more sensitive and nuanced and needs to be handled in a more, I don't know if delicate is the word I'm looking for, but like a balanced way to consider what the people who are coming to these meetings and what they're deliberating about. It's like weightier
I'm hearing-
situation than a select board.
I'm hearing what you're saying
Yeah.
in the context of what Commissioner Schultz was saying, which is that the commissioners are being asked to pull together information and work full time on developing this body of work and a report. And the work of a select board typically is more to look at a piece of business, discuss it, vote on it. it is different, the tasks that we've required those public bodies to do. But I think we'll get Tucker in here and we'll dig into this section. So we'll put in a page, top of page 11 here. Sub D is going to get quite a bit of review from us next week, I think. All right. So let's put a pin in that one. We'll have Tucker back. And we've got sections 10 and 11 here. Are all that's left, right?
Yep. So the affinity group sections, degree of confidentiality. So this provides that the meetings and sessions of affinity groups. So I would just change this over to groups established pursuant to subdivision 906B13. Shall be confidential and privileged. Commission staff and participants in a group session shall be subject to a duty of confidentiality and shall keep confidential any information gained. Person who attended may bring a private right of action for damages resulting from a breach of that duty of confidentiality. And that section doesn't limit or otherwise affect the application of common law confidentiality and any action that may be brought based on a breach of that duty. So
I did ask House Judiciary's Chair, Representative Lalonde, to try and find a little bit of time to take a quick look at this. We don't know anything about civil court and rights of action and here in GovOps, so I'm going to ask for them to do a drive-by on this and give us some feedback.
all right, and then 11 is the appropriation and 12 is effective on passage. So that covers it. I've got some drafting instructions here, so I'll get started. But I think depending on, unless the committee prefers a strike all amendment, I may hold off on the actual amendment text because I won't know exactly what you want till then. So up to you. Do you like instances of amendment or a strike all?
I think since, well, especially the removal of affinity appears multiple times, I think it'll be much easier to do a strike all unless anybody has a problem with that.
I'll start on a strike all.
Okay. I'm assuming that'll be a little cleaner for you too, Damien, right? To do a strike all.
Yeah, strike alls are always great because I don't get the questions of, but wait, what does this refer to? Yeah.
There are a few too many times that word affinity appears. I think that's going to make a decision for us.
Yeah, I'm just glad we're not a state that does their statutory amendments like instances of amendment. Massachusetts does that. Reading their legislation is brutal. You have to have the statute book open next to you.
Oh.
And it is, anyway. So,
Representative Hoover, go ahead.
Early in this process, you mentioned 3 is not good, 5 might be good, 7 might be good. Is there anything in their internal governance designating a chair, who votes, who doesn't vote, if the chair is designated, things like that, that they are going to determine?
for the selection panel,
For any of this?
so the commission, the 3 commissioners are all equal. There's no chair of the commission. At least I don't think there is.
No.
So it's kind of like the moment of hesitation. Did I forget language? The selection panel does appoint a chair, but action is by a majority of the members present and voting, I believe. So and a quorum requires a majority be there. So, but yeah, with the selection panel right now, it's at 5, which were the original 5 who selected the 7. The original group of 5 who selected the 7-person selection panel, and we've just kept it to 5 for purposes of simplicity. I think, really, unless you see someone who's missing that you think belongs in that selection panel, 5 is probably okay. We did have an early draft that had a selection panel of like 21 people. And that was taken away because of, you can imagine how difficult it would be to get anything done.
Seeing the biggest reaction from our refugees from the House, y'all.
Yeah, but I've literally, I mean, it was just, kept adding groups that would be interested in the work. And finally, it was narrowed down to the smaller group that could be representative of multiple interests. But yeah, I don't think there's any magic number unless you see people missing who shouldn't be there.
Thank you all very much. We will pick this back up. We're on the floor at 3, so I'll give everybody a little bit of time to get things together and
Thank you very much.
thank you.